It might be worth beginning now. We seem to have a goodly audience. A few people may come in later on, students being what they are, they probably only just got up. So we'll just have to make allowances for that. Right. Without further ado, I will introduce our speakers. The motion before us today is that Corpus Juris, which is a proposal in essence to form some form of harmonised or common European legal system, would be, in the words of Kate Hoey MP speaking for the government, a threat both to Britain's human rights and to our national sovereignty. We are very fortunate in that we have possibly the two best possible speakers on this issue. We have talk called Dick Erikson, who has come all the way from Rome in Italy to speak to us this evening and put forward the case against Corpus Juris. And we have Professor Spencer of Selwyn, who is a professor at this university, and who I believe helped to draft the document and who should be able to give us an unparalleled insight into what it really means. So, as I said, without any further allocation on my part, I'm not who you come to hear, I will introduce Torquil Dick Erikson.
I would like to say, start with, I'm very grateful and aware of the honour that I am being done by having been invited here by my hosts and also to speak on this momentous subject in Churchill College, named after Sir Winston Churchill, who led this country to resist a previous attempt to introduce an alien legal system upon us. A successful attempt, a successful resistance, I'm glad to say. I'm also here rather conscious of being an Oxford man invited to Cambridge, and I recall that in 1933 there was a very famous debate in Oxford on the motion this House would not fight or will not fight for king and country. I don't know what the arguments were, but the motion was carried, and it is said that Hitler and Mussolini were emboldened in their plans by this result. The same year, Oxford lost the boat race, and this induced Churchill to say, can't row, won't fight. So in some way, I am hoping to restore the, I won't say prestige, but the reputation of my alma mater. I also wish to thank Professor Spencer for having kindly come to defend, to give us the opposite viewpoint on Corpus Juris, because it has been very hard to find anybody in Britain willing to do that. As Tony said, the government's position is, this is a letter from Kate Hoey to an MP, with the ostensible aim of assisting member states to tackle fraud against community budgets, the Corpus Juris proposals envisage far-reaching changes to judicial cooperation within the EU. Many of the proposals would not be easy to square with the legal traditions of this country. Indeed, some would have implications for national sovereignty and human rights, and I can understand your constituents' concerns. This is rather, I mean, she is measuring her words, this is rather strong language coming from a minister of a declaredly Europhile government. And even the European movement, British branch, responding to Idris Francis, who is here with us today, I have the letter he gave me. They say, he sent some of my arguments to them, and they say, Torquil Dick Erikson seems to have written his article as if the report had the force of the Commission behind it, the member states of the EU were planning to adopt it, it would be applied to all areas of national law and not just fraud against the EU budget. None of this is true, they say. So their line is, it's not going to happen, it's not true, it's just a think piece, it's just an exercise by some academics wishing to while away a rainy afternoon, it seems. I will, however, show that the situation is actually very different. In fact, the documentation is complete, that it will be that Santerre and Frau Theato chaired an inter-parliamentary conference in Brussels 9th, 10th November to consider Corpus Juris. They announced at the end, Mr. Santerre said, and this is a contemporaneous note by the legal advisor to the House of Lords Committee of Investigation into Corpus Juris, who was present, said that he drew attention to the powers that the new Article 280 of the Amsterdam Treaty, and I'll be saying a few words about that later, would give to take measures combating fraud, because Corpus Juris is limited in its scope here to fraud against the European Union. And Madame Theato says she thought the Corpus Juris was on the right lines and regarded the creation of the European Public Prosecutor, that is the central proposal, the European Public Prosecutor, as unavoidable. So there is a conflict which has not been noticed by public opinion. The European Union is saying this is unavoidable. The European Public Prosecutor, who will have overriding jurisdiction throughout the territory of the Union, and we will look at his powers in a minute, is unavoidable. The government is saying, and even the European movement, British branch, is saying it's impossible, it's not going to happen. They have said that Article 280 provides for measures against fraud to be introduced by majority voting, and we've ratified that. The government is relying on a one-line safeguard within Article 280, which says these measures shall not concern the national administration of justice. But Frau Theato has already stated how they are going to get around that. She says, the limitation provided for in the last sentence of paragraph 4 of the Article 280, these measures shall not concern the application of national criminal law or the national administration of justice, covers only the law currently in force in the member states, which may not be repealed or amended by community law. It does not, however, prevent the community from introducing supplementary legislation to fill gaps in national legislation in accordance with the subsidiarity principle. So, if there is a dispute, the government says this argument they don't agree with. But this is the argument that the European Union, with all its force, is going to bring forward, as Santerre has already announced. The only thing one can presume they are waiting for is for Amsterdam to be ratified by all the signatory states, and therefore it will come into force. And when that happens, we have no reason to think that Santerre will not fulfill his promise and introduce this measure against fraud. Kate Hoey said it's ostensibly just against fraud, and in fact the use of ostensibly is justified because this program, which was distributed at the seminar in Spain where Corpus Juris was presented in April 1997 and where I was present, this program says objectives. The objectives of the seminar are twofold: to call the attention to jury, and secondly, the organisers wish to make known the content of Corpus Juris for protection of these financial interests, which has been conceived as the embryo of a future European criminal code. Now, perhaps we should be aware, very briefly, of the fact that these islands off the northwest coast of Europe have a completely different legal tradition from the continent. This is a book by Professor Italo Mereu, who is an Italian professor of the history of law, who teaches at Ferrara University, and it's called The History of Intolerance in Europe. It is the Inquisition as a model of legal violence. He writes regularly for the Italian equivalent of the Financial Times, and it shows that when in Britain we were having Magna Carta in 1215, which puts which includes the right of trial by jury. A man shall not be punished and exiled or trampled on, save by judgment of his peers. On the continent, the Inquisition was being created, which meant essentially unifying the function of prosecutor with that of judge. And the Pope of the day, Innocent III, wrote very rude letters, documented by Professor Merrill, to the English bishops and abbots who had signed Magna Carta. Well, perhaps I should move straight on to Corpus Juris itself. It reads like a mini criminal code and code of criminal procedure in 35 articles. The first half is devoted to creating to defining the offences of fraud against the European Union. And the second part, which is the part I will be talking about, defines the procedures, the personnel, and the powers. It creates a single judicial area for the whole of the EU, subject to the laws which are laid down here. This is, by the way, a proposal, so it's not yet law, but they have announced, as I said before, that they're going to bring it in. And we will not have a national veto under the procedure they are intending to bring in. And they want it strongly. The conference in November was attended by Lord Goodhart and Humphrey Malins, MP QC, for Britain, and Humphrey Malins wrote a letter to the Daily Telegraph on the 1st of January saying he was horrified. All 14 other member states said, right, fine, we'll have it. They'd already been briefed beforehand. He hadn't. He was given a questionnaire saying, to what extent are the population of your country aware of the need to have a harmonised criminal system for the whole of Europe? Well, so it creates a single unified legal area, and it sets up the European Public Prosecutor, who has the power to investigate and the responsibility of investigating crimes of fraud against the European Union. I would just look briefly at his powers. Going straight to Article 20, Powers of Investigation of the EPP, the European Public Prosecutor. Section 3, subsection G. To make requests for a person's remand in custody or remand on bail subject to conditions for a period of up to 6 months, renewable for 3 months, where there are reasonable grounds to suspect that the accused has committed one of the offences defined above, Articles 1 to 8, or good reasons for believing it necessary to stop him from committing such an offence, or from fleeing after committing it. Now, he then says, this order, at the beginning of the paragraph it was a request, but now it becomes an order. This order, in writing and giving reasons, must be addressed to the competent national legal authorities. We look at the French, which is the original, because the English version is a translation, as it says on the back cover, supervised by Professor John Spencer. It is, when it says to make requests, it says la demande. And when it says this order, it's still cette demande. I'm not quite sure, but doubtless Professor Spencer will explain why this different translation. Because he makes this request, according to a subsequent article, to a new figure called the Judge of Freedoms. Shades of George Orwell, I thought, but, rather an odd name, but the Judge of Freedom's duties are listed, but they do not include any scrutiny of prima facie evidence. So, the person can be kept inside for up to 6 months, and there is no provision for a public hearing within 24 hours, as there is in this country. So, habeas corpus has gone out of the window. And it says a period up to 6 months, renewable for 3 months. It doesn't say how many times it's renewable. It so presumably it's renewable 3 months at a time as long as the investigation has to go on. It doesn't say renewable once for 3 months. It leaves it open. Now, so habeas corpus, which was introduced in this country in the 17th century, and according to some authorities was the king's attempt to violate it was a major cause for starting the Civil War, is abolished. In fact, on the continent, it has never been known, habeas corpus. People are arrested, put in prison, pending investigation. And there they wait and they're interrogated by the investigating judge, because the investigator is a judge. In an exchange of letters which I had with Professor Spencer indirectly in the columns of the Daily Telegraph, that was his letter appeared, I think, on the 2nd of December last year, and mine on the 4th. He said that the European public prosecutor is not a Napoleonic figure. I said he is, because if you look at the French original, it says Ministère Public, and this is a creation of the French Napoleonic system. The power that they have is all there. Is absolute. We are in the lap of the... On the continent, people are in your freedom is in the lap of the career judiciary, because one member of the career judiciary, who is the prosecutor, orders your arrest. And then his colleague, who is the judge, validates this order or doesn't. But they work in tandem, on case after case after case. And there is no public hearing for a very long time, until the trial itself starts. When the trial itself starts, it says, and here we have another English centerpiece of our whole system of justice. It says, the courts, judgment stage, Article 26, paragraph 1. The courts must consist of professional judges, specializing wherever possible in economic and financial matters, and not simple jurors or lay magistrates. Not simple jurors or lay magistrates. Now, Professor Spencer said in his letter to the Daily Telegraph that the Roskill Committee, that this is a British proposal, because the Roskill Committee had already suggested that. It so happens that I was, just by mere coincidence, I was at prep school with a member of the Roskill Committee who represented the minority position, Walter Merricks, and I met him afterwards, and he said, he told me what had happened. The Roskill Committee was a group of lawyers appointed by the government to give an opinion. In fact, they produced 2 opinions, a majority opinion, which said, yes, we think that fraud is too complicated for the ordinary person to understand, and a minority opinion, which was that of Walter Merricks, which was that, yes, but however, it's very important because, an argument I think which is crucial is you can't have somebody put into prison for reasons that the ordinary person can't understand. I mean, think about the man's mother, who goes, why did you put my boy? Oh, sorry, Mum, we can't possibly explain it to you. You couldn't possibly understand. You've got a law degree. No, well, then, just forget about it. Are you an accountant? No. I mean, you can't put people in prison if the man in the street can't understand. If you do, it's tyranny, it's despotism. For the English man, on the continent, they do. They don't have juries. They don't have independent juries. Well, even the sort of partial jury court, which you have in the continent, where the judges go into the jury room with the jury people, and the summing up is delivered there in private, and they can say whatever they like, and they can make, they can turn the jury people around any way they want. Because here, if a judge in his summing up gives his opinion, it's an opinion of guilt, and he gives it very explicitly, and after the jury produces a guilty verdict, you can overturn the verdict on grounds of an appeal, on grounds of undue influence by the judge on the jury. That's correct. But on the continent, undue influence of the judge on the jury. It's contradiction of terms. That's what the judge is there for. He's supposed to influence the jury. He's supposed to guide them, to tell them what to do. So, I just wanted to read a few words here from this book, Trial by Jury, by Lord Devlin. Jury as lamp of freedom. And Winston Churchill, in whose college we are, actually mentioned trial by jury in one of his wartime speeches to the nation as one of the values that we fought to defend. Because the British, well, the English-speaking nations of the world have a conception of democracy which I call two-legged. That is, the ordinary people intervene in public affairs twice. Once, by deciding who shall write the laws, and secondly, by deciding when those laws are applied against an individual, most violently, that individual's rights are taken away and he's locked up. The ordinary people say, a random sample of them in the jury, are asked to say a decisive word. It's not the state. We don't hold with the idea that the state can lock people up. We think that's undemocratic, and we think that's wrong. And Devlin, we wrote this, I think, in the 50s, or perhaps the 60s. He said, but it's prophetic almost, he said, each jury is a little parliament. The jury sense is the parliamentary sense. I cannot see the one dying and the other surviving. The first object of any tyrant in Whitehall, he hadn't thought of Brussels, would be to make Parliament utterly subservient to his will. And, in fact, under the treaties, Parliament is. I mean, the laws made by Westminster are, if they're in conflict with laws made by Brussels, the judges' instructions now are they have to apply the laws made in Brussels and not those made in Westminster. So the first object of any tyrant in Whitehall would be to make Parliament utterly subservient to his will, and the next to overthrow or diminish trial by jury. For no tyrant could afford to leave a subject's freedom in the hands of 12 of his countrymen. So that trial by jury is more than an instrument of justice, and more than one wheel of the Constitution. It is the lamp that shows that freedom lives. To many of us, the boundaries between Whitehall and Westminster are uncertain and confused. We are anxious that government should be strong and yet fearful lest the gathering momentum of executive power crush all else that is in our state. We look for some landmark that we may say that so long as it stands, we are safe. And if it is threatened, we must resist. It is there, this beacon that 7 centuries have tended. These are the words of the, and then he quotes in Latin the first of the line of Magna Carta, section 39, which says, I said before, that no man may be dispossessed or punished or without judgment, legal judgment of his peers. These are the words of the Great Charter which Blackstone said secured to every Englishman that trial by his peers which is the grand bulwark of his liberties, and which he took as the text for one of the most celebrated passages in the commentaries. His words today are still, after 2 centuries, as fresh and meaningful as when they were written, and I wish, in closing this subject, to commend them to you. He then quotes a paragraph from Blackstone, which I won't read the whole of. But these values, these liberties that British people have fought for over generations and indeed centuries, and many have laid down their lives for, are now, as I see it, under threat. So I think that the most disturbing thing, if that were possible, is the fact that this is all happening in silence. And perhaps on this, Professor Spencer does agree with me. He says, when he wrote to the Daily Telegraph and complained that he once offered to write an article for it, and they were not interested. That was some months ago, I presume. So it is important that Corpus Juris be talked about and that people come to know it. This is very important because it is an official proposal, and they have promised they are going to bring it in via a route which does not admit national veto. Thank you.
Thank you for that speech, Torquil. And now I'd like to, if you will, present Professor Spencer to give the opposing view. There are always two sides to every story. Also, Professor Spencer.
Thank you. I suspect that I'm a lion come into a den of Daniels. But I'm not going to apologize for being part of the Corpus Juris project. I'm not going to say that I don't think it's necessary, and I'm not going to say that I don't think we thought it out properly. I'm proud of what I've done as part of it, and I value the time that I've spent involved in it. But I have to say that Mr. Erikson has grossly misrepresented, first of all, the state of affairs with how far the EU has got with it. It's never been more than a discussion document put together by a group of academics who were asked to think about the problem of prosecuting for European budgetary fraud and told, think up a solution which might work if there were the political will to implement it. It was never devised by those of us who put it together or by those of us who asked to do it for any purpose other than prosecutions for budgetary fraud, and it certainly hasn't been officially adopted by them in any shape or form. It's not been officially adopted by the Council. It's not even got the official backing of UCLAF, the European Community's official anti-fraud body. The stage it's got to is that the European Parliament expressed interest in it and wanted to know more about it and asked the people who wrote it, ultimately, to conduct a further study about the feasibility and acceptability of it, with a view to producing a further report, and at the moment I have the honour to be working on this further report. So there's no question of the European Union in any official state, in any official manifestation, having publicly adopted it. It certainly hasn't. Secondly, I don't think there's any question of the proposal being enacted by way of directive under Article 280. My view, and the view of a number of the other people on the Corpus team, is that the Corpus could only be brought about by probably amending the European treaties, or conceivably as a result of a third pillar convention if it were adopted by all the other member states. So there's no question of this being about to be forced upon us by way of a directive, and if there were any attempt to do so, it's sufficiently controversial that I'm quite sure the directive would be challenged before the European Court of Justice, and if I were a betting man, my bet would be that the European Court of Justice would say that it can't proceed under Article 280. Yes, of course, there are people who would like to see this as being, if they're pro a bigger and better European Union, the first step to something else, or who fear it might be a slippery slope down which we might slide. But of course, it doesn't have to be. It could only be extended if there were an agreement to extend it, and you only have to look at the first sections of this to see that it isn't a code of criminal law or criminal procedure for all purposes. The part on substantive law at the beginning is simply and solely about offences of budgetary fraud relating to the European budget. The debate tonight is about whether the motion is about to be as to whether this involves a derogation from national sovereignty or a dent on civil liberties. As regards the derogation from national authority, I'm not even going to pretend that it doesn't, to some degree. Yes, of course it does, because the European public prosecutor, if we had one, would have the right to control what cases were prosecuted before the courts of the member states in the area of budgetary fraud, whereas at the moment the Attorney General in England and the Lord Advocate in Scotland has the power to veto prosecutions, and the Home Secretary also has power to say what help our courts give to courts in other countries. And in the area of European budgetary fraud, that wouldn't apply, and I'd be the first to accept that within the area of prosecuting for offences of budgetary fraud, that would be something of surrender of a bit of national authority. And as far as I'm concerned, the question is whether it's necessary and desirable rather than whether it's in principle one at all, which of course it is. I think it's only a small one. Of course, it could be taken as the model for something bigger, and but if it were taken, it could only become the model for something bigger if there were political will to extend it to something else, and it could only be extended to something else if further decisions were made, and the legal basis under which it could be done would have to be different from the legal basis upon which it might possibly be done in the case of a code of criminal law or criminal procedure for offences of budgetary fraud. The government at the moment has not taken any official position in relation to the Corpus project either. There's a House of Lords Committee on Europe which has decided the Corpus would be a good subject to investigate, and last week I had the honour to give evidence to this committee together with Madame Delmas-Marty, who chaired the committee of people who drafted it. I've seen the submissions from various official bodies to this, including one from the Home Office, and the Home Office submission is that overall they don't like it, but nevertheless they think it contains a number of elements which ought to be thought about further. And they take it seriously, but though they don't like it altogether, they don't think that it's completely appalling or dreadful or contains nothing in it that's of any use. Turning to the content of the corpus itself, I think Mr. Erikson has misrepresented, in a serious matter, the powers of the European public prosecutor and how much of a threat these are to civil liberties. Of course, it's true that in some continental jurisdictions, one and the same person has the job of both investigating offences and deciding who stays in prison while the offence is being investigated. That's the model in France with the juge d'instruction. It's the model in the Netherlands with the rechtercommissaris. It's the model in Belgium with either a juge d'instruction or a rechtercommissaris, depending on whether you're in the French or the Dutch-speaking part of it. But it's certainly not part of the Corpus Juris proposal that the public prosecutor would decide who stays in prison pending the case being investigated or tried. Much sport has been made of this character called that we called in the corpus the Judge of Liberties. This person is put in the corpus in order to require the countries in Europe who don't have a separate judge who has to decide questions of remand in custody from the judicial figure who investigates to have one. It's an export of the common law idea of having a separate judge who has to authorize coercive measures in evidence gathering and, of course, even more coercive measures like remanding in custody. And there's no question whatever of the European public prosecutor having the right to tell the judge who would have to give permission, as happens in English criminal procedure at the moment, that he had to stay in prison or how long he had to stay in prison. It might interest you to know that Madame Delmas-Marty, who chaired this committee, actually chaired a committee in France earlier on the reform of French criminal procedure, which recommended the abolition of the juge d'instruction in France on the ground that it was wrong for one person to combine in one pair of hands decisions about investigating cases and keeping people in custody. And it's certainly not part of the scheme, nor, I think, even capable of being reasonably considered as part of the scheme. that the European public prosecutor would be able to throw people into custody there to rot for ages without any investigation before a court about the legality of the detention. As to jury trial, we quite unashamedly recommended, as one of the proposals, that offences against budgetary fraud should be tried before courts that didn't have juries. It's true that this proposal was made from the common law was made by the Roskill Committee on Fraud Trials in 1985 or 6. But incidentally, you may or may not know that the Home Office is at the moment considering this again and has a consultation paper, the consequences of which it's at the moment digesting, about whether we should have non-jury trials or maybe amended juries dealing with complex fraud cases. The argument against having juries in complex frauds is that they aren't the safeguard which they're supposed to be, because unfortunately it sometimes happens that jurors are not able to understand the details of a complex fraud. Furthermore, on the continent of Europe, juries certainly aren't regarded as the safeguard of civil liberties that we regard them here. The French introduced them after the Great Revolution and then saw them consigned to the guillotine in France, about 17,000 people in jury courts at the time of the Revolutionary Terror. And although Lord Devlin said in his book that jury trial is the lamp by which freedom lives, and with the implication that you can't have a democratic country without them, I'm interested to see that the Netherlands got rid of jury trial when they kicked the French out, because they regarded it as a French innovation and an invasion on their traditional legal scene. And I think in practical terms there are few more democratic or liberal countries than the Netherlands. Furthermore, if the corpus came about, and if there were enacted as part of the corpus a rule that budgetary fraud offences had to be tried without juries, I fail to see how that's the end of jury trial, given that budgetary fraud offences are only a small number of offences. On the subject of inquisitorial prosecutors, it's also, which of course we recommend the European public prosecutor being somebody who combines investigative powers and also the duty to conduct the prosecution. It's wrong to imagine that that's an innovation in the common law scene, because in 1987 we introduced the Serious Fraud Office, and the director of the Serious Fraud Office is the original inquisitorial prosecutor, having the duty to investigate and the power to ask questions and the power even to require questions to be answered by the suspect in the case on pain of fine if he doesn't answer. And if you go back further than that, Customs and Excise are the body which at present investigate most budgetary frauds in this country, and the Customs and Excise have the most extraordinary inquisitorial powers. I don't like either of those very much, and I would add that the powers that the Serious Fraud Office has at the moment and Customs and Excise have at the moment go considerably beyond the powers of investigation that we proposed for the European Public Prosecutor, and we've been criticised in this country by some people on the ground that the inquisitorial powers we propose are too soft, and they don't do what some of the inquisitorial powers that our own national prosecutors in fraud cases have at the moment. We're asked to consider whether the Corpus Juris would be an unacceptable threat to civil liberties. I concede that it's a derogation, I think to a small extent, from national sovereignty. Completely decline to accept that it's a derogation from civil liberties. The defence rights in the Corpus Juris project are well safeguarded. It's provided that the defence enjoy all the rights guaranteed by the European Convention on Human Rights, including the right to silence, actually a right to silence wider than they have in English law at the moment if somebody's being prosecuted by the Serious Fraud Office, and something else they don't have in this country, an automatic exclusion of illegally obtained evidence, whereas in this country, if evidence is illegally obtained, the court has a discretion as to whether or not to admit it. Mr. Erikson said he didn't think anybody in this country had come forward to defend the Corpus Juris, and I was rara avis in terra, being prepared to come forward and say anything in favour of it. Well, I'll tell you one body which has publicly backed the Corpus Juris, and that's an organisation called the Fair Trials Abroad, which is a defence organisation, the energies of which are devoted to helping Britons who are being prosecuted in the continental legal systems, and foreigners and legal systems anywhere in the world, and also helping foreigners who are being prosecuted before our courts. And their angle on the matter is the following, that all the problems prosecutors have prosecuting people in transnational cases are reproduced, only worse, if a case actually starts to be prosecuted and there's a defendant in respect of the defendant. Defendants have acute problems defending themselves in transnational prosecutions if they ever get started, for two reasons. The first reason is that if a foreigner is before a court, the court is always very reluctant to grant that foreigner bail, because they're afraid that he'll run away and there isn't any legal machinery other than extradition by which that person can be got back again. So foreigners tend to stay in prison pending trial, whereas nationals of the country don't. Secondly, there are no legal means at the moment by which the defendant who's in one country can conveniently extract evidence from the country next door which he might need for his defence, because the courts in England have no power to compel evidence from the courts in another country. The witnesses have to be in another country. We may or we may not like increasing movement and increasing doing business with the rest of Europe, but inevitably it's had the consequence that far more foreign nationals are being caught up in the legal systems of the other member states than was ever the case before. And one of the consequences is that the number of people in the European Union who are at present remanded in custody in the different courts of the member states has gone up from a few hundreds to a good many thousands. And the Fair Trial Abroad angle on the idea of a common European criminal justice system is that it's essential in order to safeguard the defence rights of defendants in a country where far more defendants are actually facing trial outside the countries of which they're the nationals. So I completely reject the argument that the Corpus Juris involves a threat to civil liberties, although, as I say, I'm quite prepared to concede that to some extent it involves a dent on national sovereignty. Thank you.
I'd like to thank, on behalf of all, Professor Spencer for his candour in defending what is apparently indefensible. Professor Spencer made a rather good job of it. I think both of our speakers have agreed to questions from the floor. I'm not quite sure how up to speed everyone is on the technicalities of the Corpus Juris proposal, but I'm sure our speakers will be prepared to answer more general, wider-ranging questions. I would ask for all questions to be addressed in a polite, civil manner and to be kept as short and succinct as possible, so we can squeeze in.
To both speakers, it's been issue that's slightly been raised, but do you think the threat, if it is a threat to habeas corpus, is in conflict with the European Convention on Human Rights, and do you think that that convention is likely to protect us from it if it does become a threat?
Yes, the European Convention on Human Rights was signed in 1950, I think, by a series of states, some on the continent of Europe and some on the offshore islands, which include this one. And the ones on the continent have never had habeas corpus. There is no right. I mean, habeas corpus means that when you're arrested, you have a right to for your body to be exhibited in public within about 24 hours after your arrest, whereas it doesn't happen on the continent. You're not seen in public for a long time sometimes. And so the European Convention on Human Rights says nothing about that. Actually, when it comes to procedural safeguards, all it really says is this famous phrase, a fair trial in a reasonable time. But it doesn't say what fair means or reasonable. In this country now, in Scotland, there's a statutory time limit, I think of 110 days. It was always in Scotland, but they've introduced it into England too. If they can't bring you to trial within 110 days, then the case gets dropped. On the continent, it can be years sometimes. According to there have been moments, there have been historical phases. I mean, I'm talking about the post-war period, when people were kept in prison for years before their trial was concluded. So I don't think the European Convention on Human Rights is really much of a safeguard. It's the lowest common denominator between the signatory states. If it had had habeas corpus, then the continental nations wouldn't have been able to sign it, or they'd have had to introduce habeas corpus into their own systems, which they haven't done. In fact, they want to take it away here.
To begin to correct what I consider to be that incorrect answer. First of all, the European Convention on Human Rights provides not only the right to a fair trial, but before trial, the right to have a judge rule upon the legality of your detention. Secondly, the habeas corpus has nothing whatever to do with criminal procedure in this country, and has had nothing to do with criminal procedure in this country since 1816. Habeas corpus is to do with testing the legality of a detention, not whether it's wise in the circumstances. What we have these days is the right to appeal to a higher court against the refusal of bail by the magistrates. You have to have somebody who has judicial status to remand you in custody in the first place, and you have a right of appeal. You've got that to a greater or lesser extent in the continental countries. In some of the continental countries, not very efficiently. In some of the continental countries, quite efficiently. They vary sharply among themselves in how long it's thought to be permissible to keep people. It's true that in some continental countries, trials can take ages to come on, and people can spend 2, 3, 4 years in custody pending trial, which is unthinkable here. But I fail to see why the fact that that can happen there is something which is automatically bound to happen here if we have the Corpus Juris project.
By far the most effective way of stopping fraud against the community budget would be to fire the Commission. The second most effective way of stopping it affecting us would be for Britain to leave the EU altogether, which we could do by an Act of Parliament within 24 hours. I could go on for hours, but I won't be allowed to. If anybody wants more detail on this, I have a thick file of documentation, including all the correspondence, the analysis, and the official papers. Anybody wants to see me afterwards, I'll give you my address and phone number so I can copy them to you. I'll now come to a question. The European Union has been for 40 years and will remain an intention to build a single country with a single flag, an anthem, a currency, a police force, an army, a navy, and an air force, and everything else that goes with a single country. It means the abolition of this country. How, in those circumstances, can you conceivably imagine that the European Union will allow us to retain a legal system which is different from all the others?
I think that was directed largely at...
The United Kingdom is a country with 3 different legal systems in it. I don't see any difficulty in a further united Europe which retains essentially different legal systems with enough common rules to enable them to work effectively when you have trans-border problems, as the legal systems of England, Northern Ireland and Scotland now work effectively when we have them. In a wholly united country, we've managed to keep separate legal systems between Scotland and England since the death of Queen Elizabeth I, and I think we could manage the same in a further united Europe. I confess to being strongly in favour of a further united Europe, to the horror, I'm sure, of many people here, but I myself have no problem with the idea of a further united Europe and separate legal systems with their own traditions.
I'm just wondering how many continental states tolerate within their own borders separate legal systems. Are there any, Professor Spencer, that you know?
No, only us as far as I know.
Yes. This points to a tradition of tolerance which has here always been sought after, as against the Napoleonic tradition of unification, uniformity, just the system of prefects, which perhaps many people here are not aware of, in France, in Italy. Every local authority, you elect your mayor, but there is also a prefect appointed by the central government who has control over the police in that locality for crowd control, and is answerable only to the minister, not to the local population. So they are very different traditions, and people, we know, not many people, because our history is very different.
Can I say something else? There is no such thing as the Napoleonic system or the inquisitorial system. Each member state in Europe has its own criminal justice system. A number of them, most of them, began with the model of Napoleon's Code d'instruction criminelle, which itself was an amalgam of French criminal procedure before the Revolution, plus a lot of imports from the common law system. They've each gone their own way since and devised their own systems. The debate that we're hearing tonight about people not wanting to give up their own legal system is mirrored in debates that I've heard with people in all the other member states. It's not a question of our sole tradition against their sole tradition. They all want to keep their own somewhat different legal systems, which are different from each other as well as they're different from ours. They can. No, it's an imposition of a set of uniform rules for a restricted number of cases.
Why is it necessary?
Professor Spencer, I'd like to ask you on... I'm so sorry. Should I just shout? No. I wanted to ask you about what you were saying, that a derogation of national sovereignty by the adoption of Corpus Juris. From what I understand from reading the Treaty of Maastricht and in Amsterdam, derogation actually means it's when you're allowed not to adopt a policy because you haven't fulfilled the criteria to do so, which is, of course, why we were allowed a derogation or otherwise an opt-out on the single currency. So are you effectively saying that with the derogation of national sovereignty, it is just a temporary measure?
We're talking at cross purposes. I'm talking about the broader question of whether it means handing over a chunk or a tiny part of our national sovereignty if we had to swallow the Corpus Juris project. I'm saying, yes, it would, to a small extent, in my view, because it would mean giving up the power that at present is vested in ministers to decide to force a case to be dropped in the courts in this country, and finally to decide what person is handed over to another country for trial, and finally to decide what help is given to the criminal courts in another country in the collection of evidence. That's the sense in which I'm talking about it.
Mr. Chairman, I've been a little encouraged actually because earlier on you said that we were limited to asking questions, but then I heard the question from the gentleman here, which seemed to be redolent with comment, and so I should like to make some comments, but I'll put them in the form of a question by asking the Professor Spencer whether he agrees with me, put it in that way. My background is that I was a stipendiary magistrate and then a Crown Court recorder. I'm also on the Committee of Fair Trials. My comment or my question may seem a little bit ambivalent because Professor Spencer was kind enough to say to me earlier that he had read some articles that I have written in legal journals, and I have said on many occasions that I'm opposed to juries in long, firm fraud cases for really the reason that he gave, that the jury don't understand always, and I suspect that one of two, the reason they come to a decision is one of two. Either they think, well, they wouldn't have spent all this money on bringing this trial forward unless there was something in it, or alternatively, the reason he gave, well, we don't understand it, and so we'd better acquit. The judge has the difficult task of trying to sum up, and that means he has to try to understand the fraud, and I've had that task, and I confess sometimes it's been beyond me, because the people who perpetrate these frauds are so clever in many instances, and I think that it would be far better if we did have long firm frauds tried by a judge with two assessors, an accountant and an actuary. And to that limited extent, I go along with the idea that is mentioned by Professor Spencer, because I think that obviously European budgetary frauds are more complex than the ones that are just indigenous to this country. But does it go further than that? He did use, did Professor Spencer, the word slippery slope, and he did say that what was proposed in what is said about the idea of having international fraud tried otherwise than by jury and by an international court could be taken as a model for something bigger. And that, it seems to me, is, to use an expression which I was expecting Mr. Erikson to use, but he didn't, might be the thin end of the wedge. And very well. Well, I'm very glad that I used such an apt expression. The difficulty about trial by people other than juries in other cases, in ordinary cases, not fraud cases, is, let me confess at once, that those who sit in judicial office do sometimes tend to suffer from complaints known as judgeitis on the higher level of the judiciary and magistratitis on the lower level, which involves cynicism and becoming hard-boiled and saying to themselves, well, we have heard this one before, haven't we? And we're not going to listen to this rubbish, just on the occasion on which the rather unexpected, unusual defence does, in fact, prove to have the truth in it. And the difficulty about the professional judge, as on the continent, is, I think, that he aims to please his employers, the government in France, his colleagues, as in Italy, and although this isn't really germane to our present discussion, but I'm simply hoping this will never happen, the electorate, worst of all, in the United States of America. I just would like to mention one case that I'm rather concerned about at the moment, because it has some bearing. It will be certainly of interest to Mr. Erikson. An Italian girl, whom I know quite well, who's in her late 20s, is hoping to be a lawyer in Italy and hoping to practice a little law in this country and have a time with a solicitor here. She's been charged with shoplifting in London. She set off the burglar alarm in a store in the West End of London. She is desperately upset about this charge. I rather cynically listened to what she had to say, and after listening to her for a long time, I came to the conclusion that she was completely innocent. I do not frankly think that anybody other than juries would listen for so long and so patiently in order to come to that conclusion. I very much doubt whether a magistrate's court would do so. And it's because of the dangers involved in the thin end of the wedge and the slippery slope that I am inclined to vote for this motion, to be on the safe side, unless, Professor Spencer, you persuade me otherwise.
In the corpus, we proposed common rules for evidence gathering, common rules for evidence admissible at trial, and in the main, we proposed that for the prosecution of budgetary offences, it should be left to national courts to decide their own trial procedure, apart from questions of what kind of evidence should be admissible, because we proposed in one of the articles a list of types of evidence which should be admissible throughout. The one exception was the proposal that budgetary frauds should be prosecuted with non-jury courts. The only reason we so proposed was that we thought they were too complicated and likely not to result in any proper safeguard for the defendant at the cost of a slow, expensive, complicated trial. I've no wish to see this proposal used as anything to demolish jury trial any more widely. I think if I were drafting the Corpus project again, I would probably have said, let's leave out the jury trial bit. It's actually a detachable part from the whole, and we could have what I regard as the really important parts of the corpus without it. And the really important parts of the corpus, as far as I'm concerned, are the common rules about evidence gathering and the common rules about the evidence at trial and the common rules about a single prosecutor.
Either or both speakers, when, where, by whom and why the term subsidiarity was first invented and what its subsequent heritage is as a term.
I have to confess it's not exactly on the theme that we were...
subsidiarity.
Perhaps somebody else? Mm-hmm.
It was actually invented in the modern sense at Maastricht as a weasel word by which John Major could convince us that he had won some games and some opt-outs at Maastricht, but all of the other people could interpret it as a completely different meaning, and so that we hadn't won anything at all.
I would just say one thing about subsidiarity and the talk about federalism. Every federal constitution defined, I mean, the American one, I believe the German one, defines the powers of the central state. You know, they go so far, and the powers of the local, the federated states, the member states, where they have these areas of competence. In the European construction, this has never been established. You have the doctrine of acquis communautaire, which means once the European Union has acquired a power, it never gives it back. But I have yet to see a document which says, for example, which side of the road the traffic is going to drive on is a matter for each nation state, and the European Union will never legislate on that. This has never been said. The limits have never been defined. And so I think what we're heading for is a centralized state rather than on the Napoleonic model. Probably with prefects in each province, in each region, which are being formed now. The breakup of the member states into regions. Obviously a central.
I've practically nothing to say about subsidiarity, except to say that the final article of the corpus says that all national rules of evidence and procedure in budgetary fraud cases would apply, except to the extent that they're inconsistent with any rules contained in the corpus.
Thank you, Mr. Chairman. I'd be grateful if the speakers could be asked to expand on something that I believe was in the preamble to the original seminar. Was that in 1997? We've heard a lot tonight, very eruditely put, about this being purely for budgetary fraud. I'd like to ask, please, why in the preamble, or first of all, whether in the preamble there was a mention of las sectas, and secondly, what that would mean in relation to budgetary fraud.
I was at the seminar and I didn't see Professor Spencer there, unfortunately. But the word las sectas was in the message of Don José María Gil Robles, President of the European Parliament. He sent a written message to the seminar, and the end of his written message, which was only printed in Spanish, said that he looked forward to the extension of the Corpus Juris system to cover all fields of criminal activity, which he listed some salient ones: gun running, money laundering, mafia activity, and this rather cryptic reference to las sectas. And I asked a Spaniard there, does that mean las sectas religiosas, religious sects? And they said yes, religious sects. Put on a par with, so I wrote subsequently, half joking, I hope, Quakers watch out. The European Union has some surprises in store for you. And I was told by some Danish public prosecutors who were there that they had on their territory the headquarters of Scientology, because in Germany it was banned by law. So, yes, that is the reference, that is all I know about the reference to...
I didn't go to the seminar, not because I didn't want to go, but because I was chairman of the law faculty in Cambridge at the time, and the date wasn't one that I was able to go to. The seminar was, I believe, a seminar arranged for an association of lawyers interested in protecting the financial interests of the community in Spain, and there have been seminars for associations of lawyers for the protection of the financial interests of the community up and down the land, including in this country, ever since, in order to float the Corpus Juris project to those people. Certainly there's been a mixed response, and at the seminar we had in this country, a number of the people who are involved at the moment in prosecuting people for budgetary offences don't like the Corpus Juris and think if there's a problem they'd rather have the problem than the proposed solution. I dare say there may be people like to see the Corpus Juris project turned into the model for a single unified code of criminal procedure throughout the whole of Europe to deal with all offences, but I have yet to meet any of them. Certainly, there are quite a lot of people to whom I've spoken who would like to see the Corpus Juris project form a model eventually for the prosecution of criminal offences which have trans-border elements to them, like drug smuggling, international money laundering, international frauds not necessarily related to the budget. Till this moment, I had never heard of anybody thinking that they might like to use it to prosecute people for belonging to illegal sects, and I'm astonished anybody should actually so have thought or wished.
I see Mr. Francis has waved an impressive selection of paper, but you could just have a quick paper.
This is a report on the 11th of February conference. This is the official report on the 11th of February conference in Brussels last year. Conclusions. The issue of stepping up international judicial cooperation can be tackled both at a general level and specifically in relation to the protection of community finances. Firstly, this would be seen as an appropriate response to strong public concern throughout Europe about fraud and corruption which harm the community. A consolidation of European judicial cooperation in the field of community finances could serve as a useful starting point for a global measure. Now, global does not mean geographical, it means throughout criminal law. And that is a clear statement of intent.
I see we are running low on time, so perhaps... Okay, well, two more then, if we could make them as short as possible. First, we...
Yes, it's to really to both speakers, but I'd like clarification of this issue of Corpus Juris will go forward if the political will is there for it to go forward. Now, in the campaign for the last general election in this country, Sir James Goldsmith put forward in his speeches the difference between the European interpretation of political will and the way it's interpreted in this country. Now, people went out and voted in response to that. 811,849 people, not merely 12, expressed the opinion that they were not satisfied with the legality of what had been done with the transfer of power. Now, the speech in question which I'm referring to pointed out that on the continent there tends to be frequently a political class who see it as their job to interpret the political will, whereas in this country we depend solely on the results of elections. You have said that you're happy to see closer European integration. Would you be happier if that came about following a full and fair referendum in which the people were allowed to express their opinion, which they have not been?
Yes.
Thank you.
Yes.
At last we find something both speakers agree on. So last speaker. Yes. Last question.
Right. I don't need that. I'm sure you can hear me, ladies and gentlemen.
All
right. Well, right. Will you hold it? Yes. Good. Is your level all right there? Splendid. Professor Spencer, first of all, you told us that it is unlikely that this will go through anyway. So we wonder how much of that £1 million an hour we send to Brussels was wasted on this. I don't think it was wasted because I think it will go through. And I do believe it'll come to this country because we've heard roughly what you've said so many times before. Oh, it can't happen here. Oh, it might happen. Oh, well, it has happened, but there's nothing we can do about it. This is what I see. And I believe it will be forced upon us for very good reasons. Because it is the way of Europe. The European Commission, the commissioners take an oath of secrecy for life before they take their seat. And everything that happens in the European Commission is done in secrecy. That is the European way. It is not the Anglo-Saxon way. It is not... And if you want proof of this, one only has to see VAT. Did we ask for it? No. But we've got it. Metrification. Did we ask for it? But we've got it. Right. I will now come to a question which is rather important on this legal aspect. Because as I see this whole issue, It is not only the European way, it is very much the German way. So whereabouts in this wonderful document, Professor, is something dear to our hearts in this country, presumption of innocence, and another aspect, putting people into double jeopardy? In other words, if they don't like the result, they will try you again, something that hasn't been exercised in this country for centuries.
Article 31 of the Corpus. Any person accused of one of the offences set out above is presumed innocent until his guilt has been established legally by a final judgment which has acquired the authority of res judicata. There's, I beg your pardon? Like the Birmingham 6. There's also a provision which says, that I can't put my hand on it at the moment, that people can't be prosecuted here, as I recall, for offences for which they've previously been prosecuted.
Can I make a quick response to that?
Okay.
Mr. Chairman, I think it's unfortunate, slightly unfortunate, that the Professor should use the word fraud when he was in his dissertation, considering the revelations from Brussels last week. But more important than that, I think that his references to the Home Office, original opening remarks, his discussion of the Home Office, what possible evidence can anything that the Home Office do when they will cease to exist probably within about 5 years' time, with a function being taken over by Brussels? Yes, I just wanted to say something about double jeopardy, the right ne bis in idem, the right not to be tried twice for the same offence. In many countries, I don't think this is dealt with here. An appeals procedure is not contemplated. The actual trial takes place in each member state in Corpus Juris, fine, correct. However, in the Italian jurisdiction and in, I think, many others, the prosecution has a right to appeal against an acquittal. So you can indeed be tried. You know, if they don't get you the first time, they can try again. So when you're acquitted, you're not off the hook. You mentioned, the second gentleman mentioned something about fraud, and there was also a reference to the Commission actually having been denounced for fraud by one of its employees, Mr. Van Buitenen, recently. I just wanted to point out that Mr. Van Buitenen was employed by the 20th Directorate General, Financial Control, whom he said had been watering down the Court of Auditors' reports and had not been for the fraud, going soft on it. And they responded to his revelations to the European Parliament, which, in our way of thinking, is the master of bureaucrats and civil servants, like the Commission have been described. They responded by punishing him. The 20th Directorate General, Financial Control, is the very self-same one that proposes Corpus Juris.
Well, perhaps if we could move on to some closing statements by each speaker. Just a couple of minutes to restate your positions.
I think I've... perhaps...
No, I don't want to say any more, thank you.
I think you...
In the case of total or partial acquittal, appeal is also open to the EPP, the European Public Prosecutor, as a prosecuting party. In other words, if you're acquitted, the prosecution can appeal against the acquittal and try it again. Is that or is that not the case? Or not? Page 172, top left-hand corner.
Certainly, our proposal includes a right of appeal for the prosecution as well as a right of appeal for the defence.
Unknown in this country for 400 years.
It doesn't bother me.
Perhaps we should... Excuse, could we please have a bit of calm now? Yes. Just a few final statements before we take a vote. I hope it doesn't appear too... Again, I would like to thank, first of all, both speakers for a lively and very interesting debate which has not received the coverage it merits. I'd also like to thank Karishma for the various things she's done for us. And to refer back to Professor Spencer's opening remarks, let's take a vote on the motion to see if he really has succeeded in, as it were, bearding the Daniels. So, all those who, after hearing what has been a very reasonable and rational debate by the standards of the issue, still think that Corpus Juris, or the implications of Corpus Juris, would be detrimental to Britain's national sovereignty and human rights. Could I have a show of hands? All those against the motion? I doubt it, but... Any abstentions? Well, it just reminds for me to thank all of you for being here, and to thank both of our speakers who have Talkwell's come from Rome, and Professor Spencer's come from sabbatical in Paris, teaching in Paris. So it just goes to show how far you have to go to get a good debate. Thank you all.